Welcome. I'm Gerry Oginski. Thank you for joining me. I'm a medical malpractice trial lawyer practicing here in the state of New York. Today's topic is going to be lawsuits. I'm going to guide you through the process of how lawsuits work and what you need to know before you ever walk into an attorney's office. The first thing you're going to need to know is that when you come to an attorney, the lawyer has to do an extensive investigation to find out whether or not you have a basis for a case. He's going to obtain all of your medical records. He's going to review all your records, and he's going to have an expert review your records and confirms that not only is there wrongdoing, but that the wrongdoing caused injury and that the injury is significant and permanent. And once that's confirmed by the medical expert who's reviewed your records, then your attorney in New York is going to be able to start a lawsuit on your behalf. Well, what happens after that? After that, the next step is that your lawyer is going to prepare a set of papers called a summons and complaint. Those are the allegations that are made against the people that you're going to be suing, which would be a doctor or hospital or other healthcare provider in a malpractice case. Well, what happens after that? After that, those papers are then filed with the court, which technically starts your lawsuit. And then those papers have to be served on the doctor or the hospital in order to get a response. Once the doctor or hospital gets those papers, it's called being served with a summons and complaint. The doctor or the hospital are going to take those documents and send them to their attorney. And shortly afterwards, their lawyer is going to reply to the allegations that you have made in your complaint. And that means that we call it issue has been joined. Now the attorney representing the doctor and the hospital now are in the case. We notify the court that they're in the case, and we are ready for something called the scheduling conference. And a scheduling conference in the New York State courts is something that the attorneys appear for, and they set up a schedule as to when things are going to take place in your particular case. Importantly, a discovery schedule, and discovery is the term that lawyers use in order to facilitate, to exchange documents that each side is supposed to and obligated to exchange. So a schedule is set up as to when those things get exchanged. In addition, a date for your deposition will be scheduled, as well as the doctor or the hospital's deposition. Now, a deposition is a question and answer session where you will be in your attorney's office and you will be questioned by the lawyer or lawyers for the doctor or the hospital. And typically that will take many hours, sometimes can take a day or two, in order to ask you everything about your claim and what your injuries are. And remember, before you enter into and go for this question and answer session, your attorney is going to prepare you and go through with you the types of questions that you can expect to be asked in this session. Well, at the scheduling conference in court, the attorneys will set up the dates in which this is to occur and will notify you as to when you're going to have your deposition. At the deposition, your attorney will be present. There will be a court reporter taking down all the information, all your questions and answers, and the lawyers for the doctors or the hospitals will also be present. After your deposition is completed, you will get in the mail a booklet, which is a transcript of all the questions and answers that you have given during your session. And you'll have instructions on how to go over it and proofread it to make sure it's accurate. Shortly afterwards, the doctor's deposition will be scheduled. And most clients ask me if they can be present for the doctor's deposition. And while you are technically able to be present, since you are a part of the lawsuit, technically you're considered to be a party to the lawsuit, I advise most of my clients not to come to the doctor's deposition. And the reasoning is very simple. Most patients who feel they've been injured by a doctor tend to get very upset when they hear the doctor giving explanations as to why certain treatment was rendered or not rendered. And it tends to run a little bit smoother if the client is not present, so that I have an opportunity to question the doctor directly and extensively. What I do, and what most medical malpractice attorneys in New York do, is that after the doctor has been questioned, I will pick up the telephone and call you, maybe not the same day, but certainly a day or two later, and let you know what the doctor or the other witness from the hospital has testified about. This way it keeps you in the loop and you understand exactly what's going on step by step. Another important thing to know is that You need to ask your attorney, whoever you choose, how do they communicate with you? How are they updating you on a regular basis? Are you the one who has to make the phone call each and every time you have a question, or you should be notified, you haven't heard from your attorney in months? Or is your attorney sending you regular letters or phone calls, letting you know what's happening on your case? The next stage of the litigation, after depositions are completed, is to put your case on the trial calendar. And during the course of the litigation, there will be many opportunities for your lawyer to appear in court before a judge in order to advise the court how your case is proceeding. After all documents have been exchanged, there may come an opportunity for you to be examined by a doctor that the attorneys for the hospital or doctor have recommended. And the reason that's done is so that the doctor and hospital's attorney can determine for themselves, using their own physician, what your medical condition is at the present time. And after that's done, after you've been examined by a doctor of their choosing, we receive a copy of the report rendered by the doctor. Once your case is on the trial calendar, it will sit there for a number of months until we get called by the court for a pretrial conference. That's an opportunity for the lawyers to advise the judge where we are in terms of possible negotiation to try and settle your case, or whether we have to get a trial date. If we cannot resolve the case at that point, the judge will give us a trial date, and we then must come back at that time in order to start your trial. That's it for today. Thank you for joining me. I'm Gerry Oginski. Have a great day.